welcome to our panel on antitrust. My name is Tom Arthur. I teach at Emory Law School, and I'm your moderator and first speaker. Our topic is the revised debate in antitrust, which we will dissect and discuss. Joining me to my right is Einer Elhauge, who teaches at Harvard Law School, and then Harry First, who teaches at NYU, and Gus Hurwitz, who teaches at Nebraska. Basically, our panel is about this. There has been a sort of new movement of criticism of current antitrust as it's pretty much being enforced and decided in the courts today. It has various names have been applied to it. Neo-Brandeisian has been the most polite name. Hipster antitrust, I'm not quite sure who a hipster is, but I gather it's not somebody my age.
Don't be sure. So, Leonard Cohen,
yeah,
in his 80s was a hipster. So,
well, there you go.
You know, it's not an age thing.
As you can see, we have an authority on hipsterism. Harry will clue us in when the time comes. But basically, the arguments have two or three common threads. One of the arguments is that the leading theme of the argument is that what I am going to describe shortly as the sort of synthesis of Harvard and Chicago school thinking that has dominated antitrust and its doctrine from about starting with the General Dynamics case in the 70s all the way to the Legion case in 2007. And is evidenced in various things like the 1992 and 2010 merger guidelines and other areas is deficient, and that we need to go back to something that's more like what dominated from, say, the 1940s through the early 70s. And that's one of the themes. And the second theme is a discussion about the so-called Big Five that we now read about all the time, Apple, Facebook, Microsoft, especially Amazon, and I'm leaving one of them out, but you know, everybody knows who I'm talking about. The big data companies and their platforms. So on the one hand, we have a discussion, as I'm going to explain in a minute, talking about 21st century problems, particularly in the big tech, high-tech industries, particularly the ones that work with a lot of data and computers, et cetera. On the other hand, we have a lot of discussion about the good old days and how things were done better in the old days and a wrong turn was taken sometime in the 60s and the 70s. Okay, now, before I get into my larger introduction, we're basically going to have each of us is going to talk for roughly 10 minutes. It's the standard panel position, which means they'll actually do more than that. And then,
yeah, right.
We're realists here. We're antitrust lawyers. So about 10 minutes, and then we'll have some back and forth among the panel members, and then try to save at least the last half hour for questions from the floor, from you guys. Okay. Now, to begin with it, I've already alluded to what I said is a consensus, and it's not 100% consensus, but there has been sort of a dominant view that has developed, as I say, starting in the 70s and has followed. Now, a lot of the critics, and I should mention some of them by name, Tim Wu teaches at Columbia, is one of them. He's just come out with a new book called The Curse of Bigness, a title which he's taken from Louis Brandeis, who published one of his sets of a book with some of his articles under the title Curse of Bigness. Another one is actually a person who wrote a 100-page student note in the Yale Law Journal named Lena Kahn, who wrote one called Amazon's Antitrust Paradox. A third one is Morris Stuckey, who teaches at Tennessee and has an article coming out shortly in the University of Chicago Law Review. And the common denominator of these, as I've said, is they talk about particularly high tech and data, but they also claim that current antitrust is deficient. Now, I said there was a consensus. Let me make the case for the consensus and then talk a little bit about the critics. When I say there's a consensus on this, I'm not alone in thinking this. A very prominent antitrust figure, Bill Kovacic, who teaches at George Washington, who formerly was the chair of the FTC, and before that a commissioner, and before that the general counsel of the FTC, and has been widely circulated with international antitrust bodies like the International Competition Network. Bill wrote an article in 2007, it's 2007 Columbia Business Law Review, page 1, talking about the DNA of antitrust, and he called it the Chicago-Harvard DNA of antitrust. And what he was commenting on is, while there used to be pretty distinct views, the so-called Chicago School was created by writers like Robert Bork, Richard Posner, Jim Liebler, Frank Easterbrook, and others of their fellow travelers who had strong criticisms, most prominently in Bork's 1978 antitrust paradox, criticizing the existing array of antitrust doctrine right across the board and arguing that it basically was sort of formless, indeterminate, lacked rigor. Bork was a legal process person, so he was particularly concerned about the fact that it was hard to have sort of coherent principle legal decisions. And so he argued that if, instead of trying to serve multiple various goals, like protection of small business and so forth, that it should just concentrate on economic efficiency, and that antitrust doctrine should be limited to some sort of, the phrase he used was consumer welfare, although his description was really wealth maximization, but pretty much economic factors. So protecting small businesses, being fair to little guys, et cetera, was sort of not part of it. But he's mainly criticizing the as they say, the doctrines in almost all the areas. The per se rules, merger decisions like Brown Shoe, where mergers creating a market share of 5% was too much, et cetera, et cetera. And it turns out, as he did this, the criticisms were telling. In many cases, I think they were quite accurate, and they had an impact. And part of what happened in the impact is folks on the other side, particularly the so-called Harvard School, people like Phil Arita, Don Turner, and so forth, as good scholars would, sort of reviewed their work, and in some cases said, well, some of the criticisms make sense. And what happened is theories, ultimately, there got to be a bit of a convergence. Richard Posner wrote an article called The Chicago School of Antitrust in the late 70s, where he suggested that some of the Chicago provisions were being modified, positions were being modified, some of the Harvard ones were being modified, and I think that's correct. A classic example is when the first Arita Turner volumes of the Arita Turner treatise came out in the 70s. In the book, and even the first 4 of them, they basically said, well, we agree with the Chicago guys that economic efficiency or some variation of that, consumer welfare, whatever you call it, should be the sole goal of antitrust. There should be one goal, and it should be making markets produce the best combination of allocative and productive efficiencies. Now, there was a third group that I called in one of my articles the social political group, or the multi-goal group. And there were very respectable voices in that group. Former FTC chair and Georgetown dean Bob Petoskey was a prominent writer on that, and he wrote a very prominent article in the 70s defending that position. Eleanor Fox, who's Harry's colleague at NYU and a longtime and distinguished antitrust commentator, wrote a Cornell Law Review article in those days, commenting and making sort of the same argument that no, both the Harvard and Chicago guys were too narrow. Antitrust ought to have a multiplicity of goals, among which would be protection of small businesses and quote fairness, whatever that meant exactly. But so that group's kind of lost out. And I don't mean lost out in the sense that doctrine pretty much reflected this Harvard-Chicago consensus, or formed consensus. Now, there were hardcore guys on either side that were ever sort of unreconstructed, but there are a lot of folks in the middle. And let me give you some of the examples. In addition to the Rita Turner treatise that I mentioned, there was the famous 1974 article by Rita and Turner about predatory pricing, which basically led to a whole spate of articles, which gave me many billable hours when I was an associate at Kirkland & Ellis, because I became the expert on this matter and advisor to clients. And they came out with a theory of sort of cost-based theories about how to say what below cost predatory pricing was, that have pretty much become at least part of the law that is, that exists today. What we've had here, as I say, has been sort of convergence as each side has criticized the other, at least in the economics area, and there's been some middle positions. A classic example was the oligopoly theory, which dominated merger law in the 60s, which was a pretty crude theory that said if you have a small number of competitors, automatically there would be pricing like a monopolist. It turned out that didn't actually fit the facts. And it turns out that in some cases that is true. And two things happened. George Stigler, a very prominent Nobel Prize winning economist of the Chicago persuasion, came out with a theory of oligopoly that said, well, I don't know if oligopoly theories, we've had it said by the Harvard guys, is necessarily correct, because I'm not quite sure they could do this without collusion. But if you have a concentrated industry, it's a hell of a lot easier to collude. And so Chicagoans made peace with oligopoly theory in a sense that, well, that's right. We do believe in collusion. And it's a lot easier to collude, particularly when it's a felony, and you got to do it in secret, when it's just a handful of you. And so what do we do about it? Well, they then turned out and they found out, well, in some industries, it's easier to collude or to interact without collusion. For example, if you have commodities, it's easier than if you have differentiated products. And one way to check this, if you don't believe me, I'll cite sources. In 1970, Mike Scherer, who was the FTC's chief economist back in the day, and came out with his version of an industrial organization textbook, which is one of the leaders. And I have the 1990 version, his last version that he did. And in the prefix, he comes back and he says, well, I repeat what I said in 1970 in our first edition. About a third of this book is wrong. We just don't know what third. Now, this is what real scientists say, real scholars say. I had greatly admired him for that. And one of the areas that was different between the 70 version and the 90 version was the treatment of oligopoly. And the treatment in the 1990 version was like what I've just described, that, well, under some circumstances, interdependent pricing, coordination is easy. In others, it's not. This is the consensus among industrial organization economists today, and it's reflected in the 1992 and 2010 merger guidelines. It's also reflected in judicial opinions, and it's reflected in enforcement. The Obama administration came in saying, we're going to do antitrust enforcement. By God, nobody's been doing it. And guess what? They didn't. You can't tell any difference between antitrust enforcement in the George H.W. Bush administration and the Bill Clinton administration, the George W. Bush administration, the Barack Obama administration. It's all been pretty much the same. And the new critics basically say that. Now, the new critics talk, well, I shouldn't say all of it. I haven't read the Wu book yet. I certainly haven't read the Stuckey article yet. It hadn't been published yet, but I have read the Lena Khan 100-page note. And I have to say, for a student note, I mean, this is a hell of a performance. It's very thorough and so forth. But one of the things you get, and I've read this from Tim Wu's interviews, is it all was the fault of these big, bad Chicago guys, and including my teacher and mentor, Robert Bork, which I've taken a little personally, but I'm going to speak for him. And it's just, these conservative guys did in antitrust. Rita and Turner apparently were blameless. And the Rita and Turner, if the treatise doesn't mean much to you, is now a Rita Hovenkamp treatise, which is kind of the most influential publication in the field. They had a hand in it too, as Bill Kovacic's article will point out in copious detail. So every now and then, Ms. Kahn's article sort of admits, well, it's actually true that the administrations and so forth have also kind of followed along with this. They really haven't done much. It's different. But it's still all Chicago, Chicago, Chicago. They're bad. They're conservatives. We know they're bad. Ipso facto, come on, you're on the right. I've heard the phrase conservative antitrust. I don't think this is accurate, to be honest with you. And I've just about used my time. I'll comment later with some other things I have to say. But having set that up, let me close with a question for my panelists. As I said, they talk about new industries, and then you talk about two-sided markets and network effects and data, which is very current stuff, much discussed in technical antitrust panels. We're going to talk about it tomorrow in the antitrust section for the ABA. On the other hand, they hie back to, and they cite such great names as Joe S. Bain, and talk. I'm not making this up, Richard. Yeah. And it's all there. And they talk about how things were better in the old days, and we need to go back to more of that. And so I'm having a trouble knowing whether we're talking about new wine in new bottles or old wine in old bottles. Now, I'm beginning to think it's a little bit of like old wine in old bottles.
Better. That must be better.
Well, Harry, you get a chance to make that. Well, I've said enough. Einer, what do you think?
So I guess I take the neo part of neo-Brandeisian a little bit more seriously. I don't think they just want to go back. To me, the more fundamental charge they're making is that there's been a systemic under-enforcement of the antitrust laws relative to what they think the ideal baseline is. And I guess I'm going to make 3 points about that. One, I think they're right in that fundamental charge. I do think that the antitrust laws have been systematically under-enforced. Second, I think they're wrong about the diagnosis. Their diagnosis is that the reason we've had under-enforcement of antitrust laws is because of the consumer welfare standard, and that has led to under-enforcement. I think, in fact, that the problem is instead that we've been applying the consumer welfare standard in a open-ended, all things considered, case-by-case way, and that has meant that the antitrust law application has been unpredictable and worse, not really understandable to judges, juries, or the electorate. And I think the solution is to move towards more rules and presumptions, which is similar in that way to the old sort of regime of having more rule-like approach. But it seems to me still the case that those rules and presumptions, trying to figure out which the best rules or presumptions are is something we should judge by the consumer welfare standard. So a bit more on each of those points. Why do I think they're right in the fundamental charge of under-enforcement? Well, we've got studies now indicating that price fixing has just become profitable. Like you expect to make more money than you could possibly pay in damages, given expectations because of all the obstacles that have been erected to proving particularly a class action against a cartel. We've also had tons now of retrospective merger studies that have shown that we have been mistakenly allowing mergers that turned out to increase prices, contrary to all the technocratic predictions that were being made at the time the mergers were approved. We've got more and more data as well, including at the factory level, showing that increased market concentration has in fact increased prices and reduced wages. And finally, we have the fact that exclusionary conduct cases against monopolists are rarely brought and hardly ever successful, and it is very hard to believe that there's no temptation to engage in it anymore. I think it's going on, but we're under-enforcing our laws against it. So I think they're right about that, and I think they've also brought a lot of new energy to the field, mainly by stressing that via, I would say, non-technocratic arguments that are more understandable to the general public. Now, I myself have long regarded myself as a practitioner of technocratic antitrust law and economics, so I'm a technocrat, and I think it is necessary to understand the effects of antitrust doctrines. But the fact is that it's become so, technocratic antitrust has become so complicated that I don't think most juries understand it. I think even very sophisticated judges who are legally sophisticated aren't sophisticated enough about the economics to understand it. And that contributes to under-enforcement. It means that in cases, it's very hard to prove the cases. And for public enforcement, you really need the backing of the electorate. And it is hard to get the backing of the electorate with arguments about technocratic antitrust to make their eyes glaze over. They're just not going to be moved by that or galvanized in the same kind of way. The technocratic approach has also meant that proving a case now costs millions and millions of dollars, which naturally leads to under-enforcement. And it's just become, in every case, relatively easy for defendants to raise a whole host of technocratic objections that not only require a lot of money to overcome, but are so complicated, hard to understand, that given the fact that they have the advantage of the burden of proof, a lot of judges and juries say, well, since I don't understand what's going on, I'm going to assume that they haven't, the plaintiffs have not carried their burden. Okay, so I think that's been the problem. The consumer welfare standard itself, though, does not seem to me to be the problem. Consumer welfare, obviously, I think leads to more enforcement than the total welfare standard. I think it also better comports with the law, and ironically, I think it actually better overall advances societal total welfare. Now, to be sure, it has been misapplied in particular cases. Now, I think in data markets, the problem has been that people have gotten confused by the notion of free services being offered, not really being markets, and that consumers only benefit from that. When in fact, I think what we should really understand these are, data markets are barter markets. Services are being sold in exchange for data about people, access to those people through advertising, and that is then resold for real hard cash downstream. But upstream, it's a barter market, and you can have monopoly power in barter markets like any markets. If you have a lot of monopoly power, you charge not in ears of corn the way you might in the barter market, more ears of corn for if you have a monopoly. Instead, you charge in more data, more intrusiveness of data. And so it matters whether we have monopolies, I think, for consumer welfare in things like social media like Facebook. So I would say that the big error here was allowing Facebook to merge with Instagram and seen as an advertising market story rather than the social media platform for posting photographs. I think there's also others who misinterpret the consumer welfare standard to basically permit anti-competitive harm to upstream suppliers of inputs like labor. But as I point out in my book, that's actually a mistaken interpretation. The consumer welfare standard just says that antitrust will not protect competitors from conduct that affirmatively improves the lot of consumers, that benefits consumer welfare. But if you have conduct that's upstream causing monopsony power, the only possible upstream effect is to reduce output. And to the extent that affects downstream, it's only to reduce downstream output. So it is going to, if it has an effect downstream, it'll be harmful to consumer welfare. Given this, so I think it's not the consumer welfare standard itself. I think it's that we do this case by case, all things considered analysis when we apply it. Any standard we had, any welfare standard we had, if we said in every case you got to think of everything under the SARS that could possibly judge whether this conduct enhances welfare or reduces welfare, and we're going to bring a bunch of economists and econometric studies to figure it out, and the jury and judge have to figure out the stuff, they're just not going to get it. They're not going to understand it very well, not be able to apply it very precisely, and it'll be easier to bamboozle them with bad arguments. So I think we need to move towards more rules and presumptions and doctrines that are easier for judges and juries to understand. But still, I think the consumer welfare standard is the correct standard for judging which rules and presumptions we want. Now, it seems to me this is what happens in other legal fields all the time, right? So we have the people who apply the law are applying some sort of rule that's relatively understandable to them. They did X, therefore they're liable, or they didn't do X, therefore they're not liable. But the standards for figuring that out are relatively understandable to judges and juries. And we've recognized that, the choice between rules and standards has to do with, do we get more over and under inclusion with a rule, which it tends to do it facially, or from a standard, because in application it leads to more error. But instead of making that general trade-off of over and under inclusion for rules and standards in antitrust, we've long been restricting per se rules to cases where the conduct is almost always anti-competitive and hardly ever pro-competitive. That is, we've been restricting it to cases where there are virtually no over-inclusion. And rather than comparing the amount of over and under inclusion for that rule to a standard. So I think it's time for antitrust law to move more towards other legal fields, what they do, whereas where it seems to me technocratic law and economics analysis plays a vital role, but it does so at the level of illuminating what rules and doctrines maximize welfare, given the total amount of over and under inclusion that exists. In these other legal fields, we don't expect the judges and the juries themselves to do that. We instead expect them to apply rules and standards, rules and presumptions that are more understandable to them, because that reduces error costs. So I think in this way, technocratic antitrust and neo-Brandeisian could unite on a fundamental goal, which is to make antitrust understandable again.
My students would be delighted. Harry?
Well, I certainly never try in class to make anything understandable, so I don't know. Tom's ahead of me. So Tom started out by talking about hipster antitrust. I'll just put in a word. Maybe we can talk about a little more about for Woodstock antitrust, what went on in the period between 1969 and 1979. But we'll come back to that. I heard a little bit about the excesses of the Warren Court, which I always thought was a wonderful court. But so maybe there's some different views in the room about that. But I want to, I agree a lot with what's been said. Panelists always say that, but I want to come back at the end to pick up on maybe on some of the things that Einer said, and probably echo some of the things that Tom said as well. But I do want to, I want to start by sort of, I see a camera, expanding the lens a little bit from technocratic to giving you an exam question. So who wrote, antitrust is a subcategory of ideology necessarily connected to the central political and social concerns of our time? Any takers? So it's Robert Bork, and he wrote it in the Antitrust Paradox. So Bork understood something that, to some extent, I think that the current critics do understand, and sometimes we, as sort of antitrust lawyers who burrow in, don't understand, which is that rhetoric's important, and politics are important. And in the end, this isn't a technocratic exercise, and it wasn't even, although Bork made what he called consumer welfare sort of the centerpiece of his book, a term, by the way, that he invented, and which then has gotten misused and changed over time, as Einer mentioned. Bork's book was a political book, and he, probably differently from many other Chicago school writers, I won't necessarily include my semi-Chicago school colleague, quasi-Chicago, right, my quasi-colleague. No, my excellent colleague. He was upfront, I think, about his political concerns and his view of antitrust in a sort of traditional liberal sense about what it was about. And part of it was being concerned about the power of unelected judges to sort of make things up. And part of his concern was simply freedom, the ability to enter into markets, have the opportunity to compete. Now, he did apply his economic theories, and I'll talk a little bit more about that as we go on, maybe. But at the heart is, I think, a political debate, and it's a debate that's not only going on in the United States, it's going on in one way or another around the world, actually, wherever antitrust is. And thank God now, if you don't know it, antitrust is everywhere. So it's spread around the world, one of our great exports. But this is a very hot debate in Europe as well. So I'll read you a quote. This is a speech by Commissioner Vestager, who is the Commissioner for Competition in the European Commission, speech she gave in January of 2018. And she's a knitter, by the way. She always knits. I don't know. I can't do economics and I can't knit, so I don't know. So here's the quote. When you knit, you spend most of the time following a pattern, moving forward one stitch at a time. But however satisfying that may be, you still need to know that your work has a purpose, that when it's done, you'll end up with what? A sweater, a scarf, or maybe an elephant, is what she said. So in a sense, antitrust is now looking up from its knitting, and a lot of the knitting has been a lot of technical work. Sophisticated is a great word. A lot of it very good. You know, you can agree or disagree, but a lot of effort going into really trying to make, you know, what is a contract combination and restraint of trade, trying to make that operable so that companies can have some idea of what they're allowed to do, lawyers can counsel, litigants can litigate, you know, the kinds of things that we know as lawyers you have to do to get from sort of the words on the page to actually in the court and deal with problems. But at some point, you need to look up from knitting. And I think that's what we're doing at now. So my sort of bottom line is that Chicago School is alive and doing poorly. So I'll start with the doing poorly, then I want to talk a little bit about the alive, and then maybe some suggestions for where we might think about going from here. So the doing poorly, I think in part, both Tom and Einer have indicated what the critique is, although the critique does, again, go outside the comfortable antitrust sphere. You know, when you have a note done by a third-year law student that, you know, that ends up as a 4-page spread in the New York Times, you know that something is going on, right? So if something's happening here, don't know what, don't, you know the song? Well, anyway, Stone Ponies. Okay, so the Council of Economic Advisors in 2016 issued a report called Benefits of Competition, Indicators of Market Power. The report's been criticized in many ways, and from an antitrust point of view, there are issues. But the thrust of it was things have gotten a lot worse. Markets are more and more concentrated. The under enforcement, we've allowed mergers to go forward. Corporate profits have been increasing, but there's declining rates of entry, which contradicts the sort of the simple Chicago School model. High profits invite entry. Wages have stagnated. Another issue that for antitrust tends to be outside the narrow focus, but has become politically very important. This is in the background of Piketty's book about wealth distribution and how things are going bad in that area. And I think a general consensus, in a rough sense of what consensus means, is that what antitrust was supposed to do in general, which was to keep the markets competitive, to keep profit rates down to some manageable level, not monopoly profits, not zero profits, obviously, and some sharing of the benefits of our economic system, not just with capital, but with labor. None of this was going right. And if antitrust is the legal prescription to deal with this, there's a fault with antitrust. Something's wrong. So that's the economic critique. And it was paired with the rise of the platforms, the Frightful Five, as they were called, by Farhad Manjoo, who was the time the tech critic in the New York Times. Here's his right. This is New York Times, 2017. We are all of us in inescapable thrall to one of the handful of American technology companies that now dominate much of the global economy. That's writing that it's not just people in this room read. This is writing that's read by a larger group of the elite. I don't know. And a way of thinking about this, the top 5 companies by market capitalization in the United States in 2006. One was oil, ExxonMobil, heavy manufacturing, General Electric. You remember General Electric, right? This is 2006. To me, that's yesterday, but not that long ago. And banking, Citigroup and Bank of America. So what was the fifth? Microsoft. 2006. 2016, Alphabet, Google, Apple, Amazon, Facebook, and what was the fifth? Microsoft. So Microsoft's the thread, the tech thread through this, and that in its way, I think helps us to see the dramatic change, really, or disruptive change in our economy. So the focus isn't on the depredations of the banks, although it could be, but on these platform companies and how do we deal with this? And in this, the antitrust authorities have been pretty quiescent. Pretty is the wrong word. In the United States, not in Europe. So at times of disruption of the economy, we often, this is an historical pattern actually, think about it, we've called on antitrust law to do something about it. That's how we got the Sherman Act in 1890 as the economy was nationalizing, railroads, oil companies and all of that. And people said, something's wrong, we need this response. And Congress responds with a law. In the Depression, in the 1930s, after sort of looking to corporatism as a way out and codes of fair procedure, then came what was probably the greatest enforcement of the antitrust laws under Thurman Arnold, Yale law professor, from about 1938 to 43. So Roosevelt moved back towards antitrust enforcement, break up cartels, so a lot of the standard things we do. So that was a response then. The third that I would point to is when we started to realize that intellectual property and innovation was really important to our economy. Sort of the new economy people were talking about at the end of the last millennium. And that things, again, were changing from hard property to what you can think of as soft property. We had an antitrust response, and that was the Microsoft litigation, monopolization litigation, brought in the Clinton administration in 1998. So we've had some enforcement, but then everything goes dark. So this is the, it's doing poorly. We're missing something. So as for the alive, let me see, how many minutes did you say? 10 minutes?
Yeah, about
turn into
10.
15? Oh, all right.
We've got till 10:45 for the whole program.
I could just, I can take this. So I have
Well,
another
but
50.
others-
Okay, so on
half
the
hour for
alive.
questions.
Right, yeah, I'll leave if I have to
Leave
leave
5
a
or
few
6
minutes.
minutes, Harry.
So on the alive, if you think that this debate, Harvard, Chicago, who cares? I don't care about those two schools. I always thought New York was the center of the world. It's an old thing. It doesn't matter to anybody. I offer you as a case in point for how these ideas echo today. And this is the alive part. The American Express case, Ohio against American Express, decided by the Supreme Court last year. How many of you have American Express cards?
It's the best.
I know how to say that in Japanese, actually. Don't leave home without it. Anyway.
You're not going to demonstrate.
Hmm?
You're not going to demonstrate.
Dekakeru toki wa wasurezuni. Ni. Don't leave home without it.
Anybody know if it's true?
Okay. So this is a case, for those of you who don't know, it involves a contractual restriction between American Express and the merchants that accept it. And if you have an American Express card, you want to use it and get all those great rewards, right? You really want to use that card. And so you really want to use that card. So merchants feel that this desire for consumers to accept it makes it really important for them to be willing to accept that as well as other cards. So they call it a non-discrimination provision. or an anti-steering provision. Merchants are not allowed to say, you know, if you use your Discover card, we'll give you free shipping. Or if you use Visa, we'll give you gift wrapping. Or we'll give you a discount if you use Visa or MasterCard and so forth. Now, why might merchants want to have said that? American Express charges them a lot of money to process their transactions, more than MasterCard and Visa. So they would like to steer people or sell people, say to them, look, you know, it's cheaper, I'll save money, you'll save money. We call that a deal. Consumers, you would think, might like that. So do any of you, when you get gas, do you go to gas stations that have cash or credit pricing? Sometimes I do. I have that. I don't know if any of you do. And you sit there and try to figure out, now, do I want to give up my reward? You've done this, right? Yeah. Try to figure out this calculation. Let's see. I get what percentage rewards on this card. It's a little, but if I'll give it up for, you make that, as a consumer, you can say, I'll give up my rewards for a lower price. Right? Now, you can do that because Congress passed a law saying that you can't penalize, you can't stop people or merchants from steering you towards cash. Right? There are all sorts of other issues with that. But so that you can do. But other things which merchants really would like to do, they can't do under this non-discrimination provision. So this gets up to the Supreme Court. And I'll just read to you, because I've got another half hour. But I'll read to you from the oral argument, Supreme Court. You having trouble? Okay, no, it's okay.
We need to start over.
Yeah. So oh my God, I can hear. All right. So this is from the oral argument, and it's 1 minute and 22 seconds into the oral argument. The Solicitor General for the state of Ohio is standing up. You can hear in his voice, this is his first argument in front of the Supreme Court. And it's a little daunting. We're all sitting up there like that. 1 minute and 22 seconds in, Justice Gorsuch says, the antitrust laws are aimed at protecting consumers. You'd agree with that. So, given that, there's no evidence of restricted output in this case, correct? Mr. Murphy, I would agree that it's ambiguous. There's no one way or the other about whether it has restricted output, Justice Gorsuch. And that's normally what the antitrust laws care about, is deadweight loss, the restricted output. That's the primary concern of antitrust activity. Wouldn't you agree, Mr. Murphy? Correct. All right. So at this point, in a minute in, Gorsuch is echoing Bob Bork. Because when Bob Bork used the term consumer welfare, he didn't have consumers in mind. It's just a great term. He was great at rhetoric. So for consumer welfare, he meant, as other panelists have said, total welfare, the welfare of society, making us all richer. Us all is not necessarily you or me. It may be rich people richer. It doesn't matter. So that's what he meant by consumer welfare, output. And this is what Justice Gorsuch focuses in on. And unfortunately, poor guy standing there just takes the bait and says, correct. Wrong answer. How about high price, which focuses on consumers, right, who pay high prices, and that consumer surplus is then transferred from consumers' pockets to producers' pockets, the way in which I think Einer probably thinks about consumer welfare. The other side of that debate in the 1960s is also in the American Express case. So in the dissenting opinion written by Justice Breyer, talk about your Harvard, who had taught at Harvard, taught antitrust, joined by Justices Ginsburg, Sotomayor, and Kagan, Harvard, well, I don't know, Kagan, Harvard. She was the dean. Okay. So Justice Breyer starts out his opinion in this case in a really weird way. Here's what he writes. For more than 120 years, the American economy has prospered by charting a middle path between pure laissez-faire and state capitalism. By means of a strong antitrust law, the United States has sought to avoid the danger of monopoly capitalism. Long gone, we hope, are the days when the great trust presided unfettered by competition over the American economy, unfettered by competition. So he's stepping back and seeing this political content. We want markets to function. This is the great thing. Otherwise, that awful government's going to get involved. And he says the lawsuit is emblematic of the American approach. Many governments around the world have responded to concerns about the high fees that credit card companies often charge merchants by regulating such fees directly. The United States has not followed that approach. We're in court. And whether perfectly consciously or not, he actually echoes writing. This was a famous interchange between Bork and Bowman on the one hand from Yale, and Harlan, Blake, and Jones from Columbia about the goals of antitrust. And Blake and Jones wrote, and this is a 1963 Columbia Law Review article, which you could almost have taken, I mean, Breyer doesn't cite it, but that's because he knows it. This is part of his DNA. Antitrust makes possible the attainment of a viable economy with a minimum of political interference. Is not that the aspect of antitrust which makes it uniquely American? This was at a time when we had the monopoly on antitrust, and Commissioner Vestager wasn't talking about fairness in Europe. Antitrust operates to forestall concentrations of economic power, which, if allowed to develop unhindered, would call for much more intrusive government supervision of the economy. Exactly the point that Breyer makes at the beginning of his dissent. So we're still playing out in this current case decided last year by the Supreme Court, this difference in goals. But it's not just difference in goals, it's difference in some sense in methods, and the sort of the price theory that that Bork pushed in his book, which in a later epilogue he called not economics, but he called a powerful form of rhetoric. Bork, I think, was honest. I mean, this, if you think about the way antitrust presents economics and price theory, it's, it may get to be very technical, but it is hard. It's pretty simple, and you might say simplistic, but it is powerful because it has a powerful logic behind it. And this, in many ways, is the reason why the Blake and Jones view, the multiple goals view, has always struggled, because it hasn't had the powerful rhetoric behind it. It hasn't had an easier to apply approach. We can talk more about Amex if we want to, I have some suggestions about where we might go, and one of those suggestions is legislative, that it may be time to return to the legislatures and even to state legislatures. I'll turn it over to you guys.
Okay, so I am either going to speak briefly for far less than 10 minutes or at length for far more than 10 minutes. I likely will not speak for 10 minutes. So I think we have a really interesting juxtaposition of ideas here that I think really frames and captures the current and, frankly, the historic antitrust debate really well. So our discussion was framed initially in terms of Chicago versus Harvard, neo-Brandeisian, hipster antitrust. These are the terms that we've used so far. I think really the debate is captured really, really well between Einer and Harry. It's between technocratic antitrust and populist antitrust. And if you go back and look at the Sherman Act, you see this basic fight. The technocratic aspect wasn't really in there because the economics weren't developed at the time, but you see this multiple set of concerns that were informing the Sherman Act when it was being debated and when it was being adopted. We understood at the time that the large trusts were possibly problematic and definitely concerning in populist terms. And Congress wanted to do something about it. Senator Sherman wanted to do something about it. So we're going to do something about it. We're going to pass a law, the Sherman Act, that says combinations and restraint of trade are illegal. We're done. Well, what does that mean? If you go back and look at the debates, the answer is they didn't know. They were both mercantilist, populist. We need to protect small business from these large trusts concerns. There were these trusts are bad for, the term wasn't there at the time, but are bad for consumer welfare. They're harming us in efficiency and economic terms, and that's problematic. So really, both of these goals are embedded in the Sherman Act. And the problem, the thing that we discovered over the course of the 20th century is that these goals are in conflict. If you try and protect small business at the expense of a more efficient, larger business, if you try and say a move from 3% to 5% market share is monopolistic, anti-competitive a merger, and we need to block it, well, you're blocking efficiency, you're harming consumers. And it goes beyond this. So I'm going to disagree a little with Harry's characterization of Bork's argument. I think you're exactly right about what Bork was recognizing and what he was concerned about, but what he was trying to do was trying to remove the naked politics from antitrust. He was looking at how antitrust had been used over the 20th century and saying, look, there's a paradox here. The name of the book, The Antitrust Paradox. The paradox is that the purpose of these laws is to protect consumers, but it's being used in political ways to benefit competitors in ways that entrench economic powers and that ultimately harm consumers. So what we want to do is move, as Einer says, to a clear standard, a clear rule that puts the consumer first and says the purpose of antitrust law isn't to protect competitors. It's not to entrench power. It's not to create a vehicle for politicians to protect favored industries, to respond to populist tides, but instead to take action to prevent the rise of populism that's going to allow rent seeking and rent extraction, the formation of cartels at the expense of consumers. So really, Bork's goal was to transition us to the system of rule-based antitrust and away from the incoherent system of let's take action against whomever the winds of disfavor are blowing against at the time. That said, it has to be recognized that the Sherman Act is incoherent. It doesn't clearly say this is what antitrust law means, this is what it doesn't mean. It includes, it embeds both sets of principles. And this is the struggle that we've had with antitrust over the last 120 years or so. So a couple of additional comments beyond the framing. Antitrust today, I think, is fighting along the right margin. The fact that we are so concerned about it, the fact that we're having questions about its DNA, what its purpose is it doing what it's supposed to be doing? Well, as is so often the case, this is what we want the fights in law to be about. The easy cases we've answered. Clear cartels, okay, we've answered. Most cases under the rule of reason, we've answered. The cases that we're fighting over, the Amexes of the world, the AT&T Time Warners, the large vertical transactions, the Facebooks, the data economy, the information economy cases, these are all complex network effect, multi-sided market, network industry. These are the hard cases. We don't know what the right industrial organization is. This is the interface that we've the history of regulated monopoly is about when we have these large entities that operate best at efficient scale, where you have one large firm, where you have zero prices on one side in exchange for possibly predatory conduct. I don't like using that word, but it's what the argument is there. These are the hard cases, and this is exactly what we want to be arguing about. And you know what? My takeaway is if we are arguing about these, if these are the big cases that are raising the big questions about the soul of antitrust, the DNA of antitrust, I think the Chicago School is alive and well, and we should keep it around, because these are the things I want us to be arguing about. And this tells me antitrust law in its current form is doing great. The edge conditions, these important, hard, difficult cases, we should take our traditional approach and say, antitrust law, it does one thing, it does it well, let's leave it alone. And you know what? I will totally be on board if we want to have a large, popularly informed national debate about legislation for how to regulate specific industries. That's the way to do it. Don't distort, don't manipulate antitrust. Don't risk the consumer welfare standard. Don't risk this thing that has worked really well in order to go after these really hard cases that we might not have an answer to. So a couple more specific points. One of the real puzzles to me is if you... Okay.
That was agreement.
Yes, that's... I'm right. Maybe I should just stop. Yes, a couple of narrow points. Looking at a number of recent high-profile cases, we have Amex. It's going to be really interesting to see what comes out of Amex. But one of the big points folks have been saying who are concerned about the Amex opinion is that it creates an impossible burden that plaintiffs are never going to be able to overcome. That's effectively a de facto immunity for the large platforms because the burdens to show that there's anti-competitive harm there in these platform industries are insurmountable. We saw pretty much the same arguments being made in 2006, 2007 with the Legion case. Legion, their resale price maintenance, there was an argument, reversed the Dr. Miles precedents. The argument, the historic precedent there was that requirements on the behalf of wholesalers, that retailers have a minimum price for products, that amounted to price fixing, which is per se illegal. The court said, no, this is subject to a rule of reason. There are strong efficiencies to these practices. And you saw advocates saying this creates an impossible burden. Under the rule of reason, it's going to be impossible to successfully bring these cases. Well, guess what? We've been able to successfully bring those cases where they've arisen. A couple years later, in the Actavis case, we saw on the defense side, this is reverse settlements under Hatch-Waxman for paying entrants in the generic drug market to stay out. The defense side of the antitrust bar said, look, this creates impossible burden. We're never going to be able to successfully litigate in these cases. And what we've seen is a number of cases where we've successfully developed what we call the activist inferences, where courts have said, okay, these are the heuristics that we're going to use. We've looked at the economics. We're going through the common law process to figure out how to analyze these cases. Now, this is just the common law at work. This is how these cases are supposed to evolve. And I would agree 100% with Einer that I would love to see, I think we need to have more antitrust litigation. One of the biggest problems in this area is that the DOJ and FTC have become de facto market regulators. Instead of bringing cases, they settle cases. They use behavioral consent decrees where they say, okay, instead of litigating this case, because we're all kind of uncertain about how these technocratic rules are going to play out, we basically understand the contours, so we're going to enter into a multi-year consent decree, and suddenly the Department of Justice has become the regulator of a business or even an industry through the power of the consent decree. I would much rather see more of these cases litigated to develop the contours of antitrust law, to provide more certainty to litigants, and to get the enforcement agencies back into the business of being enforcement agencies and out of the business of being self-anointed regulators. I will end there. noting only that I would love to get into some of the more technocratic details about labor monopsony and rising industry concentration. The reports of rising industry concentration are dramatically overstated. Labor monopsony is fully within the ambit and toolhouse of standard antitrust, I'll just say. And I would love also to get into the curious contradictions from the neo-Brandesians about the exclusive and myopic focus of antitrust law on prices and price effects, which is the critique that they leverage against antitrust law, when in fact the precedents that they tend to argue for and the way that they try to approach antitrust law focuses myopically on price effects at the exclusion of quality and other effects. So I'll just queue up those as things I would like to get into.
Okay, well,
And I hope I did not speak for exactly 10 minutes.
no, you did not. Did he? Yeah, close enough. Close enough. Well,
I know. Yeah. Well, I wanted to up the average,
well. I guess
I'm
now
pretty
is the time,
transient.
if any of our panelists would like to question any of our other panelists. And then we will let you guys question us.
Well, let me add various questions for you, Harry. So my concern about the neo-Brandesian sort of approach, I would say, is mainly that it might actually lead to under-enforcement. And that's mainly because the standards are a little vague. So, for example, we should take into account political considerations. How are judges supposed to weigh those against economic effects? Or, that we should just pay attention to how big or concentrated markets are without necessarily tying it to monetary effect, but then just what is too big? Or we should just say, was competition reduced? But that doesn't really quite answer the question of, if you have a merger that makes a firm a more aggressive competitor, there's fewer competitors, is that more competition, less competition? There's a variety of things that was true of Brandeis himself, right, during that era. And because it was hard to predict, antitrust was viewed as something to ignore, because basically if you might get zapped randomly if you do this or you don't do that. Why pay attention? Could be a lot of enforcement, but unless it's predictable, it doesn't really change behavior. And of course, Brandeis himself, because of the bigness thing, was under-enforced cartel law against small businesses. So should I be concerned that we're going to go back? Because I think the big move for me in antitrust was actually from Brandeisian to Thurman Arnold antitrust, where he made it exclusively about efficiency, and it was totally consistent with very active, in fact, much more enforcement, but also enforcement along a margin that firms could predict and react to. So what's going to change that problem with the Brandeis approach?
The panel needed some real neo-Brandeisian. So I think you're right. I think the problem with one of the reasons why Bork succeeded so well was not just the narrower goal, but a goal with an easy to apply tool. And one of the problems in that debate, as you go back and look at the debate, is on the other side they had lots of goals, which I find okay. I mean, but no tools. So it didn't say how we're going to actually get those things accomplished in court. And that's still the problem. Now, I agree. I think there are some contradictory things that if you were going to deal with them, you would need to deal with them legislatively. So the question of size is, I don't know how under the current laws you achieve this. So one of the approaches, which I think requires some really strong thought, is a new statute that either caps mergers by size. This is back to Woodstock, because there were proposals then, which of course failed, or looks at oligopoly industries that have hung on for a period of time and has some legislative sort of mechanism to deal with that, maybe by breakups. I think I don't think we're going to get that legislation, although the Democratic proposals, there were two proposals in the last Congress, one of which, as it labeled a discussion draft, would have gone that sort of route. So I doubt we're going to get that kind of approach. But I think that the way in the end we'll try to deal with some of these is by making more conscious realization that some of the things we've used in antitrust are actually proxies for some of these goals. So a renewed attention to trends and concentration, which was part of the 1950 Act, would proxy for some of the issues about large size of companies generally. We might see some of that. Although, you correctly say that we could very well take account of labor markets in sort of standard antitrust and see whether there's a monopoly problem and all that. The truth is we haven't. This has been the only way, and this actually goes back to Thurman Arnold, the only way we've dealt with labor. First, we nearly wrecked the antitrust laws by trying to use the antitrust laws against labor unions, and then
Cartels.
viewing labor unions as in league with industry cartels. So other than that, labor has been like the third rail of antitrust. Enforcers don't touch it, and there's no money for private parties to touch it. So it's outside of the building trades and that kind of thing. There's been very little. So I think we could develop that. The idea about protecting small business, I think in the end, unless we protect the opportunity to compete, which I think is perfectly consistent with the case law and with traditional antitrust, and I'd look more for exclusion cases. So I think that's the way we'll protect small business, but not through protectionism that raises prices to consumers. Bottom line is I can't get through my head why this whole group doesn't like low prices, particularly for the distributive effects. If prices go down, more people with lower incomes can buy things. That's not a bad political aspect to looking for low prices. So no one wants to give up their Amazon Prime, and Amazon provides a lot of low prices. I'd be very skeptical, as I was the attack on Walmart, the previous iteration of this group.
With this article, this is the Lena Khan article.
Tom is showing that he actually did read it.
What did Amazon do? Yes, you want to look at my notes?
Right.
I can prove it, Harry.
Condolences.
I have evidence. But her main complaint is Amazon's prices are too low.
I don't.
Now, the neo-Brandeisians are saying Amazon prices too low. That's why they're bad. And that's bad.
So for me, that's a non-starter too. We should have had.
I think Brandeis would agree with that. He'd call it the competition that kills. It's also a title.
Well,
No, I think she's wrong, but I'm just saying.
He also wrote Chicago Trade.
right.
Yeah, he did.
And the cracking patents case where he allowed, the Standard Oil and their co-conspirators to divide up the market through patent licensing. So, because it wasn't a monopoly yet. Brandeis is a way more complicated figure than they want to make him. He was brilliant, and he wrote brilliantly. I knew I could get that I'm in favor of Brandeis. So you all remember the idea that the state should be economic laboratories free to experiment. New State Ice Company, 1932. Fabulous opinion that he wrote. So I think the state should get involved and start thinking about using state antitrust law in a more creative way than the federal government and federal enforcers have thought about, or the private. We shouldn't forget private enforcement, or the private parties can do, because it's not a paying proposition. So I'd like to see New York State change its antitrust law to incorporate some.
This is one of the reasons that we actually haven't seen a great deal of change post-Legion. a large number of states do still have state antitrust prohibitions on RPM. So
And they don't, it was always under-enforced.
Yeah.
The truth is, they never brought as many cases as they talked about. So another aspect of.
But I think it's worth highlighting, have a demonstration here of what happens when you have too many things that you're trying to get one branch of law, one legal tool, antitrust, to do. Do we care about low prices? Do we care about preserving entry? Just two things right there. Well, if we really like low prices, so we've got Harry's perspective, low prices, good. But then we've got Lena Kahn's perspective of, well, too low prices prohibit entry. They create a barrier to entry. So low prices, bad. So the analysis immediately gets more complicated, and this is just with two factors thrown in. Once we start throwing in more and more factors, we're overloading what we can expect one policy to do. Okay. So having the background policy of a consumer welfare-based antitrust law that handles the basic cases, and then addressing the more complex industries on a sector-specific basis seems a much more prudent approach.
Okay. Well, we've talked enough up here. I'm sure you all would agree. We have about 20 minutes left, so we'd like to take questions from you guys. Richard.
Yeah, I have a. Sure.
Yeah.
Yeah. One of the things that's most troublesome and puzzling about the Lena Kahn article, amongst others, and Tim Wu makes the same, I think, mistake, is why is it that they assume that even if you have tech companies that are dominant in product markets with all their network effects, that somehow or other this inhibits wages? The labor markets are completely different in terms of their market shares. The number of options that you have as an employee to work somewhere else, if you don't work for one of the big companies with all the startups and everything else, is much greater. And if you're trying to figure out what it is that makes wages stagnant, and by the way, they're up 3.4% last year, mainly because of the Trump reforms, God protect us, but I think it's probably true. But if you start looking at, if you wanted to understand labor markets, why would you start with the general monopoly question as opposed to worrying about explicit rules that in fact do regulate labor markets, the anti-discrimination laws, the various minimum wage laws, the Fair Labor Standard Act on overtime. One of the things that literally almost killed tech was the proposal of Perez to sort of raise the cap for overtime from 23,000 to 47,000 people, where basically every graduate student and every tech startup guy would now be subject to overtime restrictions for things that did not work. And the market on startups literally went like this under Obama and turned around the day that Trump took over because all that stuff was removed. So I'm going to make the opposite of Gus's criticism. It's not to disagree with you. It's that what happens is not only do we look at antitrust law with so many different purposes, but in many times what happens, we don't look at the direct forms of regulation in given kinds of markets and attribute everything to a sort of diffuse monopoly effect of one kind or another, which I don't think can be dealt with. And so I would argue, consistent with consumer welfare, by the way, he did not mean consumer welfare. He meant the sum of consumer and producer surplus, right. Although he didn't define it that way. I mean, unfortunately, it's a very bad term, is why don't you start thinking about deregulation in other markets? Because I'm not as fancy as Einer, and I have complete skepticism about these fancy new, we could find a monopoly everywhere kind of papers that one sees. But this is simple stuff in terms of the basic theory. As you start imposing minimum wages and overtime regulations that are contrary to market behaviors, you're going to inhibit competition. And I think the great advantage of the Chicago school on the antitrust side, going after cartels primarily, ignoring predation and so forth, is you're going for low-hanging fruit. And in this particular case, we're leaving the low-hanging fruit on the trees and pursuing some of these other kinds of theories, and it seems to me that that's really a very big mistake. I don't quite know whom this is directed to, but I am staring at Harry and Einer.
So I have not seen papers that share your premise. Like I see attacks on tech market monopolies by the neo-Brandeisians and I see their concerns about labor market stagnation, but I haven't seen them say that it's because of the tech monopolies are causing the labor market stagnation.
Tim Wu's book comes awfully close to saying.
Okay, I haven't read Tim's book.
Although,
I mean,
consider yourself blessed. It's an elegant book, but it is really way over.
Also, Maurice and Marshall Steinbaum, his frequent collaborator, I think pretty explicitly make that argument.
huh, okay, so, well,
Marshall does.
you'll have to tell me what the premise of it, but I have seen other articles that, well, there's been other articles focused on just labor market concentration, the purchasing a level, and basically it seems to me what it suggests is we've just been misdefining labor markets. Labor markets have been defined too broadly, and they've been assumed too much substitution among different sorts of labor, too much geographic mobility, and if you define the markets properly, you find that they're much more concentrated, and you can link it to lower wages. And that, at least the critique that I've seen, and sort of perhaps the
This is in the face of a huge migration of labor out of places with right to work laws into places that don't have. I mean, the labor markets have become quite mobile, but again, if you're trying to look for the elephant in the house, the thing that you're most going to care about is whether or not you have a right to work state, because the union participation in places like this,
right.
you can see Illinois is basically dying on the vine, and all of its competitors that have done in Michigan, and Wisconsin, Tennessee, whatever it is, they've done just fine.
Well,
And it's labor out
Won't
migration.
federalism take care of that? I thought you liked competition between the states.
I'm
and
just
that'll take care
telling
of
you.
it.
I mean, of course I like competition.
So we're done.
No,
All right.
no, Harry. I like competition. What I don't like is monopolies, which are put into place by state governments. And that's why the new ICE case was so terrible, because essentially it ratified certificates of convenience and necessity for entering into businesses on an experimental model. It was a dreadful decision, because you've got to look at what they were protecting. They were protecting the wrong things. And to this day, hospitals have been unduly concentrated because you have to get these entry barriers. And it's a classic case in which they pretend that these are all health and safety issues, when in fact they're just classic cartel maneuvers which are fig-leafed over.
Yeah, you raise a nice point that I think is worth emphasizing as part of a focus on the neo-Brandesian antitrust movement, which is any micro or macroeconomic ill that they perceive is attributed to monopoly. And there are many causal factors. If you look at wages in the United States over the last several years, economists have been scratching their heads and debating left and right about why is it that as unemployment has been dropping so quickly in the United States, wages seem to be flat. And there are lots of arguments, there are lots of explanations, they're starting to tick up that have nothing to do with labor monopsony. But to the neo-Brandesians, this is a clear demonstration of a monopoly problem that we should use the antitrust laws to solve. If antitrust is your hammer, then every problem is, yep.
So a couple reactions. I think you're right. I think to some extent the writing uses antitrust as a label, not as a law. So it's a much more powerful political label. I mean, I think you gave the answers. You said it. Why aren't they talking about attacking the right to work laws? Why? Because politically, you're going to attack the frightful five. I mean, that seems to me simple. So I think that's an explanation for now. So to say, shouldn't we be concerned about state restraints on professions, on all sorts of things? And the answer is yes. I mean, this is sort of a bread and butter traditional antitrust issue that is a perennial because the states keep popping them up, and every once in a while they get to the Supreme Court. Supreme Court's now been knocking them down, actually. So yes, there should be more attention to that. I think, and we have, and I guess I could say I'm guilty of this as well. Just sort of overlook the idea that there are competition problems in labor markets, not thought about. So why has it come up now? I would say Uber. So all of a sudden, it's not quite, they're not in a labor union, but they're drivers and workers. So the question of how Uber's affecting wages, this is sort of a more 21st century feeling problem. So I think that's one of the reasons for surfacing it.
But one thing you cannot do to deal with the quote Uber is to try and have a minimum wage laws for people whom you don't even know who their employer is or when they're working.
I don't want to. I mean, I don't want to say we've solved these perfectly. Yeah, obviously there are lots of problems. But if you're asking why is this group picking the targets they are, and why has labor picked up, I think there's a lot of politics in this. I don't think that's necessarily bad. I think it's partly an explanation. There is at the heart of antitrust, to some extent, a labor issue that is an uncomfortable one, and it's in the merger area to me, right? Firms merge and they say, great, it's efficient, we're gonna fire so many people. What a wonderful thing. And antitrust says, super duper. I mean, not quite.
And the alternative is bankruptcy where you fire
No,
more
it's not
people.
bankruptcy.
It is
The
often
alternative
that
is
thing.
keeping going and competing. But
Schlepping. I mean, this is the same version of the Lena Khan
no,
argument.
no.
Harry writes his own articles.
No. I think it's so to the extent you're putting forward an efficiency, you only put those forward if there's an adverse effect on competition. You say, oh, but we have this efficiency. Outside the United States, antitrust systems deal with this in part through, requirements of either retaining jobs or slow attrition, some labor conditions. We've dealt with this in the United States, actually, in railroad mergers. So, that's a small area. It's not really what this group is talking about, I don't think, but
No.
it's sort of an uncomfortable thing. But basically, antitrust enforcers and antitrust enforcement have stayed away from labor markets. I think it's a lot to do with politics.
Does anyone else have a question? Yes, please.
I have a question on a different area, and I'm not sure it's particularly sophisticated, but I've been very curious about it. I'll take the example of airlines, although there are a couple of other areas. When you have, airlines are their prices aren't identical. They do compete to some limited degree in terms of prices, but what's striking is you have multiple airlines flying the same route, and they say have 2 flights a day. One airline has a flight at 8:30 in the morning and 3 in the afternoon. The other airline has a flight at 8:35 in the morning and 3:35 in the afternoon. Obviously, that happens a lot. It's obviously not an accident. I'm curious if that's something which antitrust has gotten into at all or not.
This is over to you. Airlines.
So for airlines, the main anti-competitive mechanism, I think, is not price, it's been capacity. You limit the number of planes and flights. I'm just not aware of the data on the timing of flights. If they're very close together, it seems a little odd. I could think they could pick up, well, I guess if they're going to have a full flight anyway, I still think it could charge more if they were separated further apart. So if they're close together, it seems to me there's closer competitors in timing, and that's going to lead, I would think, to constrain prices rather than to elevate prices. And if you separate them out, you'd have more convenience, you could charge more for it. But I haven't seen any of the economics on the timing of flights.
Yeah, and the economics of the airline industry are fascinating. And when we start looking at how the flight scheduling happens, there are, unfortunately, this is an overloaded term, there are lots of not network effects, but there are network effects. Figuring out how to get your plane from port A to airport B so that it can get to airport C puts constraints on the time of day that you can leave from A to B. And the pricing between cities has very little to do with the distance flown. It's a fascinating, figuring out how to map out the network, how to price through the network leads to a lot of counterintuitive conclusions. So great area for the rule of reason.
Well, another area, though, that affects airplanes, the whole airplane industry, is the fact that you have bankruptcy reorganization. In a market economy, firms are supposed to fail and go out of business, and other people take their place. The leading airline in the world now, or second leading, is Delta Airlines, and they've been in bankruptcy. American's been the leading one in the country, has been in bankruptcy twice. And they've all been reorganized. So what's happened is you had overcapacity in the airline industry. Warren Buffett famously said, no one has ever made a nickel on airlines. And part of it was because,
But now he's invested in all the airlines.
well,
So-
because what happened though is
to move.
when you have overcapacity, the way a market works, or supposed to work, antitrust is supposed to believe in markets, if anything, is that sometimes it's an oversupply. Sometimes prices are too low and they need to go up. And the way they go up is the market sends a signal that there are too many resources in this industry for the demand, and the supply goes down. But reorganization never let it go down because you could not exit the industry. So the only way that you could consolidate is with mergers, and that's what's happened.
I don't get that because I mean, all bankruptcy does is change basically who the economic owners are, but
Well, that may be,
the
but
bondholders still are going to want, and the creditors who the trustee represents are still going to want the company to maximize profits.
no, I understand that,
Yeah.
but the companies were always reorganized. None of them ever went out of business. They never went to liquidation. It was always Chapter 11.
Yeah, it's worth more as a going concern. But
Well, there was all these other factors, people, they had
Sears is
labor.
liquidating.
no.
Well,
Delta
some
Airlines
capacity
did.
would have gone out, but it doesn't go out. So now we have four main airlines.
But one more thing about this, one issue we haven't mentioned today is the horizontal shareholding issue, which is throughout our economy, leading big corporations have the same set of small number of institutional investors often, the same leading shareholders, and the evidence indicates that when that's the case, they don't compete very strongly against each other, less strongly against each other. And the airline industry in particular, we have a very extensive econometric study that shows that on routes that are both concentrated and have higher levels of horizontal shareholding, we have higher prices. And it's also associated with lower output, so lower number of flights. So I think there is something anti-competitive going on, I guess, given that data in the airline industry.
Other questions? Yeah.
What do you all make of the proliferation of these rewards programs? Speaking partly of airlines, but also sort of it just seems to be ubiquitous at the moment.
Credit
And I
cards.
think it's that data that these companies are trying to get your data, and the data is worth something to them. But I think that used to be something of an indicator of an antitrust issue, and I'm wondering if there's if there's anything to that. It seems so ubiquitous, it's hard to believe that it is really an antitrust issue at this point, mainly.
Yeah, I don't see the antitrust issue myself just in offering rewards. I often wonder whether they're a way, though, to bribe people who are on business travel to use one airline versus another because
Speaking personally,
they personally get the benefits and
Right,
and they're making a choice and may cost their employer. So I think that that might be a concern. But paying rewards in exchange for data, as long as it's clear what data you're giving, that's the problematic part. But I don't think credit card companies, I think they've been legally
you may be
restricted.
talking
to
about two
trading.
different kinds
Yeah,
of
two-
rewards.
So
You're
Yeah.
talking about airlines, credit. There are
I
a
think
lot.
you mentioned both, right?
I get cash back on my credit card.
But in terms of loyalty programs, so your Subway cards and your Starbucks memberships and whatever,
Amazon.
one of the ways that we can think about those is they increase switching costs. So once I have associated myself with Starbucks for coffee, I've bought into their loyalty program, there's an increased switching cost there. The literature on switching costs is actually, it's a fascinating literature developed in the 1980s. Switching costs, people intuitively feel this is anti-competitive, this is harming me as the consumer. What the literature actually shows is the fact that a firm imposes switching costs upon me actually creates a competitive opportunity for other firms to step in and compete for my business by being willing to absorb those switching costs. So one of the classic contemporary sort of examples is early termination fees for telecommunications carriers. You think, wow, I need to pay $300 in order to switch from Verizon to T-Mobile. That sounds terrible. Well, actually, if T-Mobile says as part of their marketing, we'll pay off your early termination fee, that's a way to persuade me to join them. So it can be anti-consumer, but there can also be
an issue
pro-consumer benefits. So it's a surprise, as is the case with much of antitrust analysis. It's subtly more complicated and counterintuitive.
Right.
So how is that pro-competitive? Why isn't it better for T-Mobile to cut a check to the consumer for the $300 rather than pay the incumbent carrier? And if they're competing, I know, but its switching cost is increasing the barriers to
Yeah,
a competitor getting to change. I don't see how that's improving
It
competition.
doesn't, so it's not necessarily exclusionary,
It's not necessarily exclusionary,
but it might be,
There can be
depending on.
there can be positive reasons for the firms to have the switching costs, the early termination fee ab initio. So in order to cover the fixed cost of my service,
Okay, well,
that's a good reason for Verizon to pick on you. You're sitting in front of me, so congratulations, I'm a loyal customer. There could be good reasons for them to do it, and any anti-competitive concerns can be assuaged through a competitive response, a market response.
Any other questions? Well, we'll finish a minute early then.
Well, that was efficient.
You could have gone on longer.